Washington mornings on the Mall. 105.9 FM. And AM 630. WMAL.
7:07 on WMAL. Brian Neiman, Brian Wilson with you.
Hey.
About an hour from now, we're going to talk to Homer Hickman. You know, there's this thing that's going out there, private money to mine asteroids. I just find that to be very fascinating.
What?
Do we have the ability to even do that? We'll talk to Homer about that.
That'd be very interesting.
Deborah Burlingame will be on the program at 8:36. You know, her brother was the pilot of the plane that was hijacked and flew into the Pentagon, coming up on the one-year anniversary of the death of Osama bin Laden. That's all to come in the 8 o'clock hour. Right now, Joe DiGenova, our legal expert, joins us. Good morning, Joe. How are you?
Good morning, Brian. I'm just fine. Good to talk to you guys.
We had a interesting conversation this morning at the 5 o'clock hour about this controversy. I'm surprised it's a controversy. I'd love to get your take on it. There are many states where if you're charged with a violent crime, so you're charged by police and prosecutors with murder, rape, armed robbery, they can swab you for DNA. And in Maryland, that was the policy. It's the policy in Virginia as well. And D.C., apparently, you have to actually be convicted before they can swab you for your DNA. But the Court of Appeals in Maryland said that the state can no longer do that. They say it's a violation of the Constitution. It's unconstitutional. I'm guessing it's search and seizure.
Right.
What do you make of that? I mean, is this a violation? And do you ultimately think this will go to the Supreme Court? And how will it go?
Well, I think it will go to the Supreme Court. I think Maryland is going to appeal it. Now, the Supreme Court doesn't have to take the case, but they probably will. This is a very bad decision. Let's look at what they said. You're arrested. You're in custody. Now, here's what they can make you do now under the law that's constitutional. A, they can strip search you.
Right.
They can put you in a lineup. They can take your fingerprints. They can empty your pockets and everything you own and go through it. They can take your photo and send it around the world. This court has ruled that they cannot take a cotton swab, put it on the inside of your mouth, and take a DNA sample. This is beyond stupid. This is basically a political decision. It's ideological. It's anti-intellectual. And let's remember precisely what they're doing. They're saying that the most reliable type of evidence, DNA evidence, which can actually show that you're innocent, cannot be taken from you.
Well, that was our take on it, too. We didn't quite understand.
It's not much different than fingerprints, really.
Well, I mean, there is no invasion whatsoever here. I mean, you can even have blood drawn, for heaven's sakes.
Well, then
this is really a purely ideological decision by 5 very liberal, lefty, and may I say, Democratic justices on the Maryland Court of Appeals.
At 5-2, though, I mean, that seems like it's that's significant.
That's the end of it in Maryland, but the Maryland Attorney General, Doug Gansler, has the right to go to the U.S. Supreme Court, and I predict that he will. Mm-hmm. Remember, Dougie wants to be governor.
Yeah, that's true. Now, in D.C., I mean, it's not even the policy, though. I mean, should it be of the policy where you swap for? I would think that would be one of the first things you do after you do the fingerprinting was to get DNA and then try to link it to a crime scene.
Absolutely. In fact, it's going. It already is. The feds do this automatically. A couple of other states have struck this down, just like Maryland did. Minnesota and California have struck down arrest swabbing for DNA. But the federal courts have all upheld it. So, I mean, this thing is going to the Supreme Court, and I think the Supreme Court, unless the ruling is based on a state constitution, which this was not, this was based on the U.S. Constitution, I think the Supreme Court's going to take this and they're going to reverse this.
All right, so now we have Eric Holder, the Attorney General of the United States, and the investigation over what the Justice Department knew and when they knew it regarding Fast and Furious. Mm-hmm. The Republicans on Capitol Hill who've been investigating this thing feel like they've been stymied and blocked at every attempt to get the documents that they need. They say they get blank documents, they get non-responsive documents. They know there are documents in the system that they can't get their hands on. And so now comes word that they are considering the possibility of a contempt citation against the nation's top law enforcement officer. What do you think about this?
Well, let's play this out. If they vote contempt, what happens under the statute that exists for contempt of Congress? They send it to the U.S. Attorney for the District of Columbia, who is an Obama appointee. And while he is a very decent man and an honorable guy, Ron Machin, he is not going to prosecute his boss for contempt. That's not going to happen.
So it means nothing.
It could, except for the following fact, which very few people know, but because you have me, you are going to know.
Okay, well, that's why we want you here.
The House of Representatives has the inherent authority to conduct a contempt trial on its own on the floor of the House. They do not have to forward a contempt citation to the United States Attorney, and they have done so in the past. In fact, you may not know this, but there is a prison cell in the basement of the Capitol,
Really?
which used to be used to lock up people who were held in contempt of Congress. Now, that hasn't been done for 175 years, but let's remember, old is new.
Now, if the House holds a contempt hearing, does the Senate have to then convict? Is it like impeachment, or is the House?
The trial is held. No, the contempt is of that particular House, and they conduct a contempt trial on the floor of the House, just like the Senate would do. Now, the Senate has a special statute. They can go to court and conduct their own civil contempt citation to hold someone in civil contempt. They can't lock them up, but they can get them fined and they can force them to turn over documents. The House does not have that authority.
Wow, that would be something else if that were to happen on the floor of the House.
Yes,
and that's why I guess the Speaker is weighing it.
They are not going to do that because John Boehner does not want the spectacle of that going on. So my guess is this is a dead letter because the Justice Department is not going to, it'll go to Ron Machin. That the statute reads that it goes to the U.S. Attorney in the district in which the contempt has occurred.
But hold on. I mean, the Attorney General, even though he's the Attorney General, doesn't have the right to withhold documents from Congress.
I agree. There's no question about that.
Then there is a legitimate reason to go forward, is there not?
The only remedy for this, given the situation, may very well be a new election, which is coming up in November. There are some things that the executive branch does for which there is no remedy, like the Vietnam War, for example, or the Tonkin Gulf Resolution, which was a fraud. I mean, there are some things which are clearly illegal, unconstitutional, and in this case, maybe even obstructive, if you believe what the House members say about the Attorney General, but for which there is no remedy because it simply doesn't play out. By the way, the U.S. Attorney who gets the referral from Congress is not required by law to actually present it to a grand jury.
All right, before we let you go, this John Edwards trial, which we get a lot of, information, we kind of giggle out and go, man, what a jerk this guy was. But from what you've seen so far, is the prosecution doing a good job of actually showing that John Edwards broke laws?
No, I think this is a very bad case. As you will recall, we talked about this when it was first indicted, and I told you that I thought, first of all, I don't think John Edwards violated the law, and I don't think the other people around him did. I think these were gifts given with a specific purpose of helping him out. I don't believe these were campaign contributions, and I think that I cannot conceive of ever having brought this case as a criminal matter, maybe as a civil matter to seek to have the funds restored, but this is not a criminal case. It never should have been. You can never tell what a jury's going to do because they may not like John Edwards because of what he did to his wife and how he cheated on her and all that.
Right.
But as a matter of law, in my opinion, this was a very bad case. It never should have been brought, and I don't think they can prove a crime. I think even if a jury finds him guilty, the judge may set it aside.
Really?
Yeah, that's something.
All right, Joe. Thanks as always.